Are we done with the e-notebook or some of our stuff?
All right, well, welcome back from lunch and welcome to our Select Water Committee meeting. This afternoon, we have a few topics that we'll be covering, and we'll be starting out with the groundwater appropriation and management. This was one of our interim topics. And so our good staff has prepared a memo on this for us. It can be found on the legislative website on our meeting materials. It was not there before, but I'm assured it has been posted now. So for anyone, any members of the public who are listening online, you can find that information there. And so David, would you like to take us through the memo this afternoon?
Certainly, Madam Chairman. And this is just kind of for introduction. It's a kind of a summary of the groundwater statutes that we've got currently and how those work. It is more of an overview, and certainly happy to do any deep dive that the committee may wish to have in the future. But essentially, the Wyoming legislature first enacted laws regulating underground water in 1945. They made some fairly substantial amendments in 47, 57, 69, and 73, but there haven't since then been any kind of real overhaul or very substantial amendments to those particular statutes. With regard to underground water, the right to use it is a vested right with the priority dating either from the completion of the well, the date of registration with the state engineer, or the date of filing an application with the state engineer, really kind of just depending on when the well was built, and because all of those laws kind of combine. So it does require a bit of a look to see exactly what that priority date is, whether it was before 1945 or registered after. Currently, though, if you want to build a well, you do need a permit from the state engineer. The rights to underground water are subject to the same preferences as surface water, and rights not preferred may be changed to a preferred use in the same manner as surface water rights. Watering for stock, household use, or for non-commercial gardens or lawns does have a preferred right over all other uses, regardless of priority, where the irrigation area does not exceed 1 acre and the flow does not exceed 25 gallons per minute. An appropriator of underground water does not have the right.
Go ahead. Representative Summers.
Madam Chairman, thank you. So it just above there, it says, you know, it's the same preferred right as surface water. And then you go down and say that, no, these uses have a preferred right. They don't have a preferred right with surface water.
That's true.
So which way is it?
Well,
and what does it mean by a preferred right?
Madam Chairman, so to start, I'll just jump over to the surface water statute, and we'll take a quick look at that. And that is in 41.3.102. The preferred water uses shall have preference rights in the following order. And that just provides it water for drinking purposes for both man and beast, water for municipal purposes, water for the use of steam engines, general railway use, culinary, laundry, bathing, refrigerating, and then finally in industrial purposes. But then, you know, they do kind of carve other things out, even within that statute. So within the underground water statute, it does say that the preferred, the preference is the same as surface water. But then it does in that same area or in those same statutes carve out that kind of exception for specifically for that relatively limited use when it's less than 25 gallons per minute. And so that would just give them, when you're dealing with competing rights, it would give them that preference over another right. I would rely on, frankly, the state engineer to kind of see how that works in practice, because I'm not entirely sure, but that is at least what the statutes say.
Go ahead.
So, Madam Chairman, I guess I am curious if there was an aquifer out there that was being irrigated and also had homes on it, and there was eventually some kind of call on that aquifer. Does that mean houses have a preference over an old irrigation right? I'm looking back at the state engineer.
Maybe we'll either have you come up now or
Just keep that question.
keep that question in our pocket after our memo, and then we'll have you come up after we might accumulate some more. How's that sound? All right. So go on ahead, David. Thank you.
Thank you, Madam Chair. This next point here, that an appropriator of underground water does not have the right to have the water level or the pressure maintained at any level or pressure higher than required for the maximum beneficial use of the water in the source supply. The state engineer may also place conditions on groundwater permits as he may find to be in the public interest. Now, this kind of comes into play in the sense that someone who has drilled perhaps into the very top of an aquifer, they don't have a right to have that water level remain at the top of the aquifer. So they may have to, if other people are using it and it lowers, then they have that obligation to lower their own depth within the aquifer. A person may change the location of a well without a loss in priority within the same aquifer with approval of the Board of Control. When you're in a situation where the underground waters in different aquifers or underground waters and surface streams, they are so interconnected as to constitute effectively one source of supply, the priorities of the rights of all the interconnected waters are correlated with a single schedule of priorities relating to the whole common water supply.
Madam Chairman. So David,
Senator Hicks.
if I may, when you were doing your research, this is an issue that keeps coming up, but I've never found anything statutorily that makes, and I'm asking you if you saw anything when it talks about that single source of supply. Who's responsible for making that determination? And then what's the process for making that determination?
Go
So
ahead.
It's one thing to
David.
state it. It's obvious that if you've got a really shallow irrigation well that's right next to the riverbank, it's probably a single source of supply, but who makes the determination then that it's a single source of supply? Is there anything in statutes that says that obligation falls on who?
Madam Chair, Senator Hicks, I don't believe that there is anything in statute that specifies what that single source of supply is as far as providing any kind of specific definition for that. And I believe, generally speaking, given the control and the authority given to the Board of Control and the state engineer, that they would be the ones responsible for that kind of determination. Of course, that I think ultimately could be contested through that process if someone were to oppose that. But my understanding, and I would defer to the state engineer on that, but that it would be the Board of Control that would ultimately make that call if it's a single source of supply or not, because they're the ones that are going to be regulating
So
that.
just to follow up, then this is for our Board of Control and state engineers does that have to be petitioned? And we don't need to, we can get through the rest of the memo, but that's going to be a question does somebody have to petition then to make a determination that there is in fact single source of supply? But anyway, go ahead, David.
All right, so I think we're getting a few questions accumulated maybe for the state engineer, if you've got those written down, and we'll get to you next. So go ahead, David.
Thank you, Madam Chair. And that portion of the statute does as well authorize or give corrective controls to the state engineer and allows them to take some measures, which we'll talk about in just one moment. And then one other side note, dealing with byproduct water, which of course is water that's the byproduct of some non-water related economic activity, perhaps mining, things of that nature. When that has been developed only as a result of that activity, that water may be appropriated in the same manner as groundwater when it's intercepted before or when it's readily identifiable and prior to commingling with other water sources. And when the developer of the water is either the applicant or has an agreement with the applicant. In any other case, that byproduct water would ultimately be deemed surface water and governed by the surface water process.
Representative Conrad.
Thank you, Madam Chair, and I apologize. For an education purposes, can you give me an example what byproduct water is, which has not been put to prior beneficial use?
Madam Chair, my understanding is that would be, for example, in some sort of mining operation where they're just drilling and they have produced water as part of that process. When they're not going out there looking for water, they're looking for something else, but they develop water as just part of it.
Go on ahead.
Then moving on to the state engineer and the powers of the state engineer. He's charged with the administration and enforcement of these statutes regulating underground water, and with the advice and consent of the Board of Control, may take a number of steps, including prescribing the rules and regulations. You can require reports from well drillers as may be necessary. He can require annual reports from underground water users, make investigations, make regulations concerning the spacing or distribution and location of wells in critical areas. He can establish standards for the construction of wells, require flowing wells to be capped or equipped so that the flow can be capped, and require both flowing and non-flowing wells to be constructed and maintained as to prevent the waste of the water either above or below the land surface. He can require the abatement of any condition or the sealing of any well responsible for admitting pollutants into the underground supply. Can delegate his powers to deputies or assistants or other qualified staff members. He can bring suit to enjoin the construction of illegal wells or the withdrawal or use of water therefrom, and enforce any of the provisions of law or orders issued under that. And he can establish the area of districts and sub-districts overlying aquifers within the state. When you're talking about disputes, any appropriator of either a surface or underground water right may file a complaint with the state engineer alleging unreasonable interference with his adequate well by a junior right. And that statute, there is some key language there. I would point to particularly the unreasonable interference and the requirement that there be an adequate well. Again, that kind of goes back to you don't have a right to have the aquifer at a certain level. So if your well is not adequate, there's no complaint to be made there. So there are some limitations there. The state engineer would then investigate the claim and issue a report to all parties stating his findings and suggest various means of stopping or ameliorating the interference or damage. Those findings can be appealed to a water division superintendent and then potentially further appealed to the Board of Control and the district court through the Wyoming Administrative Procedure Act. When there is one kind of carved out thing here is when there's a dispute involving a well for domestic or stock use, that the interfering appropriator may furnish water at his own expense to the appropriate location to supply that domestic or stock use. Looking at control areas, these are areas designated by the Board of Control for any of these following reasons. When the use of the underground water is approaching a use equal to the current recharge rate, when groundwater levels are declining or have declined excessively, when there's conflicts between users or are there occurring or are foreseeable, when the waste of water is occurring or may occur, or there other conditions exist or may arise that require regulation for the protection of public interest. When the state engineer believes that an area should become a control area, he reports that in writing to the Board of Control, and the board would then have a hearing and determine whether to create a control area. The boundaries of the control area, if it's created, may be modified on a petition of 5 persons owning or entitled to possession of land within the control area, or on petition by the state engineer. And when an area is designated a control area, it gives some additional options to the state engineer. He may close the area to any further appropriation of underground water until it's determined that there are unappropriated waters. He may determine the permissible total withdrawal of underground water in the area for each day, month, or year, and may apportion the permissible total withdrawal among appropriators. He may order juniors to cease or reduce withdrawals if he finds that the junior appropriators have an adverse effect upon the supply available needed by senior appropriators. He may specify a system of rotating the use of groundwater if he finds that cessation or reduction of withdrawals by juniors will not result in proportionate benefits to seniors. And he can institute well spacing requirements for new appropriations. The statutes allow for that in lieu of an order by the state engineer, appropriators can get together and agree amongst themselves on a proper method or scheme to control that common source of supply, subject to the approval of the state engineer. When a control area is created or redesignated, there is an advisory board that's created consisting of 5 members who own land or underground water rights within the control area, or are officers of a corporation that does. The members of the board are voted on by landowners within that control area. And the Control Area Advisory Board advises the state engineer on whether the underground water in the control area is sufficient and what actions to take if not. After the boundaries of a control area are determined, the appropriate superintendent proceeds to adjudicate any unadjudicated wells within the control area. And then new permit applications or applications to an amend existing right for any use other than watering, stock domestic use or various miscellaneous uses under 25 gallons per minute are now subject to public notice and hearing requirements before the state engineer and the Control Area Advisory Board. That application would be granted and the permit issued only if the state engineer finds, after receiving the advice of the Control Advisory Board, that there are unappropriated waters in the proposed source, that the proposed means of diversion or construction is adequate, and that the location of the well or the work does not conflict with any other spacing or well distribution regulations, and it would not be detrimental to the public interest. Currently, there are 3 areas within Wyoming, control areas, the Laramie County Control Area, Platte County Control Area, and the Prairie Center Control Area. And you can find detailed information of that. There's a link to the state engineer's office website that does have detailed information about those control areas. There are penalties for violations of these statutes. Any person who drills, digs, or constructs any works for securing underground water without a permit, or a person who withdraws underground water or fails to stop or reduce the flow of underground water in violation of a state engineer's order, is guilty of a misdemeanor punishable under 413616. And with that, again, if there's any, certainly happy to provide more details or do deeper dives as the committee wishes, but I'd stand for any additional questions.
Additional? Representative Conrad.
Madam Chair,
We'll
thank
take
you.
you up on
Can you help define, or more importantly, provide clarity as it relates to French well? How deep is French well included in this document in terms of addressing it, and or how deep or wide, et cetera, can that be, or is it excluded from this document?
Madam Chair, I don't know what that is.
Okay.
All right, give us a little more clarification.
Yeah, thank you. It's a great, thank you. Just for example, if I've got a pipe that's 36 inches in diameter and I blow holes in the bottom of it and I excavate down to 12 or 15 or 20 foot and water rises above that and I pull water out of that French well to irrigate, say, my land or lawn or flowers, is that included or excluded, as you pointed out here on the last page, as it denotes the penalties, any person who drills, digs, or constructs securing underground water?
Madam Chair, I defer to the state engineer on that, but I believe it would just depend on whether or not you are and I guess not being personally familiar with how that process would work, whether it is collecting water from the underground or from an aquifer or as pure something like that. In that case, I think it would. If it's more based on, evaporation condensation type principles, then I don't think so. But I
No worries.
honestly can't
Thank you.
answer that very well.
I'll
for you.
refer to the state engineer when he appears for testimony.
I think that's right. So are there any other questions for David? All right, anyone online have any questions for staff? Not seeing anyone online. So thank you, David. That gives us a great starting point and overview. And now I think we'll bring up the good state engineer if he wouldn't mind and coming up to the microphone, and we'll see if we can get some of these questions answered. Welcome and thank you for joining us on your vacation. That is dedication right there. So we'll try to get you on the road as quickly as we can.
Thank you, Madam Chair, and good afternoon. Brandon Gebhardt, State Engineer. With me, I've got Kevin Payne, who is the Superintendent of Water Division 4 out of Cokeville. And online, we've got Chris Brown with the Attorney General's office as well. He's the state's water attorney, so he can help answer some of these questions. But I will start, if that's all right, with the questions that I heard. I believe the first question was preferred use. What does a preferred use give you? A preferred use, as it's defined, gives you the right to condemn. So if you have a preferred use and the source of supply isn't adequate, then what that does is gives you the right to go through a condemnation process to obtain the water that you need for that right.
Madam Chairman, thank you. So if there's an old irrigation right, this is the question I ask, and there's a newer home right, does that home right have can it condemn the prior, by priority, a prior dated irrigation to get its water for the house? And then how far ahead? Is it like every home that's in that aquifer? Would it have that right to condemn a prior irrigation right?
Go ahead if you, and you can phone a friend there. Go ahead.
Yeah, Madam
Welcome.
Chair, if I may. So it depends on whether you're looking at surface water or groundwater. And so we're dealing with two different statutes here. So basically 41.3.102 is the preferred use statute. And it's basically dealing with surface water rights. And so it's saying you would have the right to condemn rights for them purposes under the preferred use. When you get to the groundwater domestic preference, which is under 41.3.907, I think that is more what your question is, and whether an irrigation well would be turned off for whatever it may be, whether it be domestic is the only thing could do it. And so to your question, yes, the domestic well could turn off the senior irrigation well only under that purpose. And as far as the extent of how far, that probably would need to be determined by some sort of study. Does that help?
Follow up. Go
Madam
ahead.
Chairman, thank you. So let's go back, because that was not how I understood the way he read it. So that I understand now. So let's take the surface right. And because I think the stock water in the same bucket as human water. And so you got a stock water right, or, which all of us, I think, have some kind of stock water right associated with it. Maybe not with our irrigation right. So you would be able to shut off, and this would make sense from how Wyoming grew up, that you'd be able to shut off a irrigation right to water your cow, even if you had a junior cow, a stock water right.
So gentlemen, I see Chris has his hand up. Do you want to keep going, or would you like to defer to Chris to weigh in now or later? It's up to you.
I'll defer to Chris, but I did want to point out one distinction between the groundwater preferred use and the surface water preferred use is groundwater preferred use specifically says that it gets priority over all uses. So it's a super priority in the groundwater statutes. And I'll defer to Chris to chime in on those answers.
All right, go right ahead, Chris, when you're ready.
Thank you, Madam Chair. Chris Brown with Wyoming Attorney General's Office, and I very much appreciate the ability to participate remotely. My schedule seems to govern my conduct more than I would like, so I appreciate the opportunity to do this remotely. I don't disagree with anything the state engineer or the superintendent said, but I want to try to pull a couple of things together. Typically, the preference only relates to, as the state engineer said, the ability for a preferred right to condemn a non-preferred right to supply its use. And that is largely the product of how the ability to change uses under Wyoming water law has evolved over time. Don't really need to get into that. I don't think, but we can. There's a distinction in the groundwater statutes, as the state engineer just mentioned, where 413907 gives an absolute preference to stock and domestic groundwater rights, where the right not to exceed 25 gallons a minute, regardless of priority. And so that's kind of this idea of it doesn't matter if the stock right or the domestic right is junior or senior, it gets a preference over all other uses. But it's not completely unqualified because the statute also says subject to the provisions of 413911. And I think it's identified in the memo that LSO provided that when you go look at 413911, it allows specifically a stock and domestic groundwater user to bring a claim of interference against any other user, but it allows for reasonable interference, and it also must be an adequate well. And so it's not just a blanket, if there's any interference with a stock or domestic right, the other right automatically gets turned off. It's going to be dictated by the particular facts and circumstances of each case to see whether or not, one, it's an adequate well, and if there is interference, whether or not that interference is unreasonable. And that ties back to this notion of no well, no groundwater right carries with it the right to a static water level. That 413911 also provides the ability that if there is interference with a stock or domestic right, that the owner of the right that's interfering can replace that water. So it's not just that the irrigation right in Mr. Speaker's hypothetical or example gets turned off. If the interference does exist, the groundwater, the domestic well is adequate, the irrigation user could replace that domestic water to avoid being turned off. So it's not just automatic, other rights get turned off. There's other things to take into consideration.
Right, one last follow-up. I've been guaranteed.
Madam Chairman, thank you. So let's just assume that you have several houses or stock water rights. You've got several irrigation rights. And so you've decided there's an interference between the irrigation right and the housing and the stock water. Would then the houses and the stock water rights go by priority? So they're both preferred rights, but would then they go by priority, or are they just, how does that work?
Madam Chair and Mr. Speaker, the statute explicitly says that if the interference is between two stock or two domestic rights, then priority controls. So whichever domestic right is senior wins.
All right, any other questions on that? Then I think we had two more questions. Did you get them all written down, Brandon?
Madam Chair, I believe the next question was who determines a single source of supply? Is that Senator Hicks's question?
Correct.
Thank you. And I'm going to have to phone a friend because I don't remember what statute this relates to, but it is the state engineer who makes a determination for one source of supply. And I don't believe, and Chris, correct me or jump in, but I don't believe that it requires a petition to make that order. I believe there are examples where just knowing the situation, the state engineer has determined in the past that this particular instance is the same source of supply as something else. And Chris, elaborate any more if you'd like.
If I might, Madam Chair, the state engineer is correct. The statute is pretty simple. There's no explicit process that's spelled out within that statute. What we've seen historically is that question can come in front of the state engineer through a few different avenues. The ones that I've been involved with or familiar with are through permit applications, where through the review of that application process, it appears that there could be interference between or a single source of supply between groundwater and surface water. We've seen it in a formal written request for regulation, where a senior surface user would request the regulation of junior groundwater users. We've seen it through the interference complaint, the interference process, the 413911 that's identified in the LSO memo. So we've seen that. We even saw it come forward in an interstate dispute specific reference. And so there are a number of different avenues that the question has been placed in front of the state engineer, and through which the state engineer has made a decision about whether or not the groundwater and the surface water constitute a single source of supply.
All right, follow up, Senator Hicks?
Yeah, so that's one methodology, but it's my understanding those can be extremely complicated and take a number of years to actually figure that out. Who bears the costs associated with making that determination, or obviously, because if it's contested, so state engineer makes a determination based on, let's just say, field inspection of the site, makes a gut feeling that it's highly probable that it's going to be a single source of supply, but yet that's contested or protest. They protest then to the board to control the decision. And then who is ultimately responsible for making that, incurring the cost associated to make that definitive decision based on the preponderance of the evidence?
Madam Chair, I'll
Go
start.
ahead.
And Chris, feel free to jump in, but it kind of depends on the avenue it comes through. If it's an interference investigation or a complaint, then that statute requires the complainant to pay $100 fine, or not fine, fee to start it off. But that is, in my knowledge, that's the only mechanism for revenue for somebody to pay the state engineer. Otherwise, the state engineer's office would be burdened with that cost.
All right, did we get that one? All right, the next one I think was about the French well from Representative Conrad.
Yes, Madam Chair, French wells, they are permitted as groundwater. But it ties back into the single source of supply. A large majority of what we see are in the alluvial portion of a stream. I think in Division 4, they have several of these that are already regulated with the surface water, but it would just depend on the facts and circumstances, because you could have, say, something similar to a spring where you can do that, but it would be permitted as a groundwater right.
All right, follow up.
Thank you, Madam Chair. For clarification, Mr. Gephardt, so French wells do require permitting?
Madam Chair, any use of Wyoming's water does require a permit, yes.
Thank you.
All right, Representative Summers.
Madam Chairman, thank you. I got my own mic and I got food in me now, so look out. So this goes to my question that I threw at UW, which kind of is a sort of where Senator Hicks was headed. Well, maybe not where he was headed, but it's that topic. It's it's how are we all as a state of Wyoming, and it's really the reason I think the groundwater topic is here. I had interest in the groundwater topic mostly because I don't think we have a good handle on this very issue of what is groundwater, what is surface water, and what are their interactions with each other, particularly in the Colorado River Basin, where someday we're going to probably have to know that. And so my question is, wouldn't it be prudent to start working on that? I know there's been some studies, but shouldn't we be getting a better handle on this issue?
Go ahead.
Madam Chair and Speaker Summers, I absolutely agree. Internally, right now, our surface water administrator just retired. And we have a vacant geohydrology position that we're trying to fill. And so I heard at the last Select Water Committee that idea and question. I want you to know that, yes, I heard that. We're working on it. We're going through the process of reclassifying our geohydrology position to a higher level to hopefully get more interest. And as we fill in the groundwater administrator, both my deputy and I have talked about, we need to start developing at least an idea of what it would take to start answering those questions. So more to come on that. We're working on it. I just don't have answers for you today. And I apologize.
Yeah, and I think that's great and a great idea, but I think ultimately you may have to contract some of that work, right, with people and obviously as you develop budgets and that sort of thing, I hope that is a part of what you're doing, is bringing that idea, because I think it's something we're really going to have to get a handle on.
Madam Chair, those are the exact conversations we're having is what's it going to take? How much money is it going to require? And then we'll have to go through that process.
All right, Senator Hicks.
So the other side of this that we've had some discussion, I think even at the last meeting so we've been talking about interference, single source of supply. The other thing comes back to some of the compact issues is obviously in the Colorado River, we have a coal bed methane field down there in Carbon County that would love to just supply non-tributary water. So that's the other side is it tributary water? Is this groundwater subject to the compact or not subject to the compact? And I know that question's been asked of one of the previous state engineers, and there's a long protracted letter saying, well, we don't know, you prove it to us. That's the gist of the letter is it's not my job to make that determination that it's non-tributary water. You need to provide all the geology and the hydrology and all of that information for us to evaluate. I know the discussion that we had last time is even if that information was presented, I think it was Mr. Brown suggested that we'd still have to get approval from the other basin states before you could make a determination that it was non-tributary water. It gets back to the whole groundwater component and quite frankly, it's could be a significant opportunity in the Colorado River Basin to provide some offset for other industry folks like in the Trona if we could actually prove that was non-tributary water. But how does that fit into this position you're talking about? Is this something that we need to start looking at so you can make an adequate determination as to what constitutes non-tributary water associated with these deeper geologic formations?
Go ahead.
Madam Chair, I'll try to address that, the question of how would our plan to help address this. I think there are many, many questions that we would need to answer through a process of studies. And yes, I do think that those types of questions would also be part of our thinking as we're putting together what kind of studies we need and where.
Chris has got his hand up.
Go ahead, Chris. I didn't see your hand up by the mountains there. Go ahead.
And I just noticed I have the wrong mountains up, but they're still Wyoming mountains. Wanted to just touch base on a couple of different things. And part of this, I think, goes back to Senator Hicks's question with regard to, who pays to figure out whether or not the water is connected. And I think each circumstance can be different, but I think what we've seen historically, where some of these issues have come up or have languished for some time, perhaps in a couple of instances, there's been specific attention paid to areas, and so specific money has been appropriated. For example, for the Laramie County Control Area, I believe there was specific money appropriated for the Horse Creek area. Oftentimes, because of perhaps conflicts, the USGS has gone in and made specific studies. And so I guess I'm just trying to relate that in areas in Wyoming where we have seen conflicts, there's been specific attention and specific appropriation made in order to hire consultants in those instances to go in and do a deep dive and come up with an analysis of the connectivity and just how that system works. So that's just one thing to think about, at least historically, how that's been taken care of. And then, of course, in those areas where we haven't had conflict, there's just been no need. And so we have quite a lot of places in Wyoming where the investigation, I think, has been rather minimal because there simply hasn't been, I think, in the past at least, the need to explore those questions. With regard to the interstate question and whether or not certain groundwater is subject to the compact, it certainly is a bigger discussion. And let's take the Colorado River Basin, for example. There is no definition in the 1922 compact that describes groundwater at all. It doesn't say that groundwater is even subject to the 22 compact. I think the great weight, if not the majority of United States Supreme Court cases dealing with interstate compacts will tell you that groundwater is included to the extent that it at least materially impacts the surface water flows. And that question has never been answered. The United States Supreme Court has never answered that question. And so the only other way to get it answered is if the states agree, the states who are subject to that compact agree to what groundwater is included and what groundwater is not included, because each individual state has its own test. Wyoming's test is basically it's not connected until the state engineer determines it is. That's basically the test. In other states, like Colorado, there is a test that basically makes almost everything included. Not everything, but almost everything included. And so, for example, in the Colorado River Basin, the Bureau of Reclamation is charged by federal statute to estimate the consumptive use of Colorado River system water in both the upper basin and the lower basin. And reclamation includes all groundwater use in its estimates. And so it even estimates for Wyoming, for example, small stock and domestic. It just does a swag at what it estimates that stock and domestic groundwater use. And it's all counted in reclamation's numbers. But you can take a look and say, the only way that we can not count everything is if all the states get together and decide what shouldn't be counted. And so it isn't so much that we need to get approval from the other states about what we would consider connected or not connected in Wyoming, but if we hope to have that water be recognized as not counted in the other states, we have to have buy-in. We have to have agreement from the other parties who are subject to that agreement. And so from a CBM well sort of standpoint, the state engineer has never determined that any of the CBM wells in the Atlantic Rim area, that the water produced from those wells do in fact constitute one source of supply. Therefore, those wells wouldn't currently be regulated off to benefit a senior Wyoming surface water appropriator, but we can't guarantee that that water be protected once it passes the state line. That's really the problem. Because as soon as it gets out of the Little Snake Basin, it gets into Colorado, Colorado's just going to divert it, and they don't have to pay to do it. So that's really where that problem comes in, is whether or not all the states agree. So for example, in the North Platte Basin, the state of Wyoming and the state of Nebraska agreed to a test to say, here's the groundwater we agree is included, here's the groundwater we agree is not included. And so we have a test that the two states agreed on in that circumstance to decide which groundwater counts and which groundwater doesn't count.
We know that well. Darn it. All right. Is there any further questions on this subject? I think we've covered it pretty well for now, but I bet we'll ruminate on it and probably have more discussions. And you guys are welcome to stay there. I think you're up the next few topics. So with that, we'll take any public comments on this subject on our agenda. Is there anyone online or in the room that would like to provide public comment on groundwater appropriation and management? Going once, going twice, seeing no one in the room or no hands raised online, we will go on to the next topic, which is a Colorado River Basin update from our state engineer's office. And so go ahead and take it away whenever you're ready.
Thank you, Madam Chair, and thank you for pulling up the slides, whoever did that. Thank you. I prepared a slide deck. I intend to only go through this very quickly, but this does provide you with information to take away, or we can dive deeper into something that maybe I just go real quickly over. But go ahead and go to the next slide. The first thing I wanted to point out was some of the outreach that we've been doing recently. So we with all of the things going on, funding is one component. A lot of federal funding, a lot of state funding is going into the Colorado River. And so we have been trying to get out to the public to make them aware and inform them of what the potential is for funding for their projects, for their programs that may be developed. So we started that working with Water Development Office. You may have heard some of this and some of their updates. On July 1st and 2nd, we conducted a couple of online meetings. And then we had the Colorado River Advisory Committee in June 22nd. And then myself, my staff, the Attorney General's Office, Water Development went on a road show. We went to 4 locations throughout the state between July 9th through the 11th, and then to Bags on the 16th. Provided them with a brief law of the river. Talked about some of the recent hydrology and why we're in the situation we're in. Talked about Kevin provided a good example on what a curtailment would look like if we ever get to that point. And then we talked about some of the current activities. So what I prepared is a snippet of what we've done out in the public. So go ahead and go to the next one, Dave, or whoever. Just real quickly, you'll have this information. This is as of July 21st. This was the upper basin storage levels in each of the in some of the federal facilities. Go ahead and go to the next one. This is just showing that the precipitation for this year is running real close to the 30-year average. I will remind you, though, that 30-year average, forget the specific dates, but this includes the period that has been determined to be the worst hydrology in 1,200 years on the river, from the 2000s through 2021. They used tree ring analyses to look back over history, but that period has been said to be the driest in a 12 or 1500 year period. I'll go ahead and go to the next one. This is just some of the projected inflows into Lake Powell and the upstream facilities. You don't need to go into detail on those. Go ahead and go to the next one. And if somebody has questions, please go ahead and interrupt and we can dive deeper. Thank you. What I wanted to show here is for water year 2024. Determination has been made that unless things crash immensely, Lake Powell releases will be 7.48 million acre feet. And the lower basin is in that shortage condition where they will only deliver 7.167 million acre foot out of Lake Mead storage. Next one. Just another example. This provides next year's water supply forecast. Over on the right, you can see, I don't know what color, the first color that's different than the gray. That's 2024. What they're going to estimate will be through 2024. And then they do the minimum, the most probable, and the maximum projection for 2025. As you can see, a little bit below average still for that. So go ahead and go to the next one. We get this question a lot. When is curtailment going to happen? I'm going to say that this is not telling us that curtailment is going to happen on any given time. This is one way to think about how it could occur. So where the line is where we are. And remember, this is the 10-year running average at Lee Ferry, the 75 and 10. So the 825 million acre foot over the 10-year threshold. And then the next box down is the 775 million acre foot. Those are where we run into our first conflict points. And we've had a lot of discussion on that. But what this is showing you is that under the current operating guidelines, and we know those are going to change. That's what we're working on right now. Those will change. But under those operating guidelines, if you just projected some constant releases out of Lake Powell, what does that do to our Lee Ferry flow? So the top line is if you released 823, which is the 8.5, it equates to the 8.5 million acre foot. What would happen over the next period of years if that was the release? The next one down is the 7.48, the 7.5 million acre foot release. When would you hit those potential points? And then the bottom one is if that release were a constant 7.0 million acre foot, when would you hit those potential conflict points? But I do want to say that that's based on the current operating guidelines. Using that, we know that'll change. What this will be in the future could be completely different. So I'm not out saying that we're going to hit our compact compliance in 2028, but this just gives you an illustration of what could occur. Are there any questions on that?
Representative Conrad.
Madam Chair, thank you. Mr. Gephardt, as I view this graph again, so the worst case scenario would appear that we are projected or potentially projected for curtailment in 2029 with the 75 million acre feet. Is that correct?
Madam Chair, that's correct.
Thank you.
Go ahead, Representative.
Madam Chairman, what are your the long-term forecasts? Because usually you have those projections and they're like a high, one that's got a lot of precip and one that's got a middle and one. So because I think that's more accurate than showing what you could release, because what you release is whatever you decide to do. What you get is a different story. So why are you showing this and not a long-term projections, or is that the next slide?
Go ahead.
Madam Chair, Speaker Summers, I don't have that with me. Chris may be able to articulate. He attends those meetings as well. But the reason we're presenting this is just because of the number of questions we have about that. But I do want to go back to Representative Conrad's question. Like I said, I'm not saying that in 2029, we're going to be in a curtailment. I'm saying that if the conditions go, because we're under negotiations to redefine how everything is operating. And as part of that, what are our obligations under a new set of operating conditions? And that may be different. The releases may be different. So with what's coming up, I'm not going to say that in 2029, we're going to hit curtailment because there's so many things changing. So please understand that. I don't want to be quoted in the paper as saying 2029, we're curtailing, because that's not necessarily the case.
I'll strike that from my book.
Sounds good. Okay, well, let's continue on then.
Go ahead and go to the next one, please. I just brought this slide up. If you remember back in June or July of 2022, the crisis where Reclamation asked for 2 to 4 million acre foot of conserved consumptive use, which led into the draft supplemental EIS to modify kind of how the operating conditions change. Just updating you on the progress of that. It looks like the lower basin what committed up to 3 million acre foot of conserved use over the 4-year period. And from every indication we're seeing right now, they're going to meet that obligation. So I wanted to point that out. That this process was also where the upper basin committed to our 5-point plan. And so that is complete, or being completed, but just identifying that the lower basin is working towards their obligations as well. We go ahead and go to the next one, please. Okay, so now we are into the renegotiation or the new EIS on redoing the 07, the operating guidelines that you hear so much about, the post 2026 operating guidelines. And so all I'm illustrating here is these are alternatives that were submitted to Reclamation, that Reclamation is analyzing as part of the EIS process. I will note that there were a couple of other, I believe 3 or other submissions that weren't truly modeling submissions that Reclamation is trying to figure out how to analyze those. But these were all submitted as modeling alternatives that Reclamation is going through right now. Just pointing out that, remember, the upper division states and the lower division states had hoped to have a consensus alternative. We weren't able to come to a consensus alternative by the time these needed to be submitted. So the upper basin and lower basin each submitted their own alternative. And we'll talk more about what the progress or the process is to try still to get consensus. So we'll go ahead and go to the next one. Just pointing out, this is the upper division alternative and the lower division alternative. I'm just pointing out that they're somewhat similar. There are similarities in those alternatives that I think are very beneficial. Most importantly, that both of these alternatives recognize that the releases, this is how you determine what it would be released from Lake Powell. I apologize. But the important thing is that both alternatives recognize that based on hydrology, the releases out of Lake Powell may be needed to go down to as low as 6 million acre foot. So I think that's an important similarity between the two alternatives. Go ahead and go to the next one. So what we're looking at here then is what would be the operation of Lake Mead in those alternatives. And again, they're similar concepts. One's color coded, the other is not. But the upper division alternative, just kind of start with that. What this is showing reductions in use in the lower basin under a given criteria. The upper division alternative criteria would look at the combined percent full of Lake Mead and Lake Powell. So determining what that percentage full is at the beginning of the calendar year or water year, depending which one you're looking at. At a certain percentage, we're saying that the lower basin would start taking reductions. So at about 80, 90 some percent, close to, lower basin starts reducing their use till you get to a 1.5 million acre foot reduction. And then that's the static line, if you will. Under most circumstances, it appears that that's where the lower basin will be operating under. Once you get to conditions that 1.5 million acre foot won't support the hydrology, then additional reductions are required. And under those additional reductions, the upper division alternative says that those reductions are borne on the lower basin, but the upper basin would then do potentially parallel activities. And we'll get to those here in a minute too. Lower basin alternative, very similar line. Their criteria is slightly different. They're looking at the contents of all of the CRISP initial units to determine their hinge points. And their alternative for that additional one beyond the 1.5, it's calling for reductions, equal reductions in the upper basin and the lower basin on a 1-for-1. So anything over 1.5 million, then both the lower basin and the upper basin would start taking reductions under their alternative. Go ahead and go to the next one. So I mentioned some of the parallel activities that the upper basin submitted with their alternative. I want to point out, though, that these parallel activities would be outside of the EIS process. These would have to be agreements. But the things that we would commit to if our alternative was developed would be voluntary conservation and then potential releases and recovery from the upstream CRISP initial units. If you remember, 2 years ago, we started a drought response operation agreement. We delivered water from Flaming Gorge, Blue Mesa, down to Lake Powell to protect critical elevation. This is a similar concept to that. So this is what was in the upper basin alternative. Go ahead and go to the next one. So what are we doing now? So the bottom of this, the words on the bottom, alternatives for analysis, draft EIS, the final EIS, and the draft minute. This is Reclamation's timeline that they're operating under right now. So currently they are analyzing all the alternatives that we looked at previously. They hope to, in the first quarter, second quarter of next year, to issue a draft EIS and then the final EIS by the end of the year. Their question?
Senator Kolb.
Yeah, thank you, Madam Chair. Just backtrack a little bit when you said we do the releases and it goes to Lake Powell. You know, from our point of view in Wyoming, there's just to be clear for myself and the audience, it never makes it to Lake Powell. I mean, does that water actually show up at Lake Powell? And we have increased releases up here in Wyoming, say from Flaming Gorge or a system like that. Could you help me out with understanding how that water would actually get to Lake Powell?
Go ahead.
Madam Chair, Senator Kolb, Reclamation did do the accounting and watch that very closely. And they did determine that the water if you think of the 500,000 acre foot that was released from Flaming Gorge, they did determine that did make it to Powell based on all of their accounting. It did make it to Reclamation. And Chris might have a finer point to put on that.
Go ahead, Chris.
Madam Chair, and I do have the right mountain up there for Senator Larson, at least. Obviously, that exact question has been raised in the past with regard to how much of the water out of Flaming Gorge is making it. And so we've done quite a bit of work since first engaging in the drawer releases in 2021. The state of Utah did a tremendous amount of work with regard to its uses on the main stem green that are downstream from Flaming Gorge, with a conclusion that there is essentially not enough use, not nearly enough use out of the mainstream green downstream in Utah to take up the base flows, the minimum base flows that are in the green without the extra releases. In addition, as Brandon said, because in large part a push that we engaged in for a very extended period of time to get some accounting, specific accounting that is pulled out of the Colorado River simulation system model that Bureau of Reclamation has. We got some estimates with regard to the amount of that water that made it to Lake Powell. Not all of it made it, because there is some transit loss with regard to that water through either mostly evaporation or through phreatified evapotranspiration on the way down. But we're not done trying to figure out better information with regard to the types of losses through the bipartisan infrastructure law that Brandon will talk about here in a minute. The UCRC will be engaging in a study to better understand the transit losses between Flaming Gorge and Lake Powell. So just trying to communicate that we've heard those concerns in the past. We've been very focused on getting better information to answer those questions. Very confident that the vast majority of that water made it, but we can still do a better accounting with regard to how much.
All right, Senator Hicks.
Any idea on what that threshold is for detection? It's one thing to release 500,000 acre feet of water over a period of a couple weeks or a month out of a reservoir, but what about all the other projects? You know where I'm going? 38,000 acre feet estimated with SCPP and the upper Colorado River Basin. Any of that make it to Lake Powell?
Go ahead.
Who wants that one?
Hot potato there.
Yeah, and it's really hot and I got the mic first, so Chris.
If that meant me, if I just got volunteered for that question.
Voluntold.
Senator Hicks, as you know, as part of the SCPP, we were very careful with regard to those particular individual projects to not make as a condition that water made its way anywhere, right? Because we couldn't guarantee under Wyoming state law, none of the other states, except exception of Utah perhaps now, could guarantee that water makes it to any particular place. And so there is a report with regard to the 2023 System Conservation Pilot Program that makes some assumptions, that makes some estimates. Of course, you can make the general assumption, I believe in Wyoming with a high level of confidence that if you can get that water to the main stem green portion of our system that never sees regulation, that some portion of that water made its way into Flaming Gorge and then therefore down to Lake Powell. But there is no estimate, there is no volumetric estimate with regard to how much of that actually made it to Lake Powell. That is also something that's being looked at much more closely going into the future, in addition to the transit loss study that's being contemplated for between Flaming Gorge and Lake Powell. The UCRC is also going to be conducting a transit loss study between Fontenelle and Flaming Gorge, and the Wyoming State Engineer's Office is going to be considering transit loss studies for some of the reaches above Flaming Gorge, I believe the main stem green and part of the New Fork. And so we're in the process of trying to put together the data and information that we need in order to better answer those questions into the future. I think we're still going to have to rely pretty heavily on estimates, because some of those amounts you simply can't pick up in an accurate way in the stream gauges. I'll defer to Kevin for more specific information on that. I'm sure he knows tons more about that than I do. But certainly we're working towards and identifying our data gaps and trying to fill those with some of this funding that's available in anticipation of what our future might look like.
Senator Cole.
And thank you, Madam Chairman. I'm trying to understand this in so much as our obligations go when it comes to releasing water from Wyoming. Does our obligation end when we release X amount of acre feet from Wyoming, or does it not end until it shows up in Powell? I mean, where is our obligation begin and end for what we have to do to be part of the system? Could you help me out with that question? Thank you, Madam Chair.
Go ahead.
Madam Chair, Senator Cole and Chris, please jump in. But the obligation for the upper division states is at Lee Ferry. So that is the obligation point. So ultimately, the water that is, if we're going to think of a curtailment situation, that would be, once our obligation could not be met, then the upper division states currently would have to, under those conditions, enter into a curtailment situation. And so we would have to conserve our obligation. So that would be defined by the UCRC. What is Wyoming's obligation to maintain our overall obligation? And so we would conserve that water, and then we would get it into Flaming Gorge, and then we would use estimates, and the better, as we get better, we'll know more and more accurately what those estimates are. But it would have to get from our border to Lee Ferry.
Follow up. Yeah, that was my understanding to begin with, but we keep on talking about Powell, right? Lake Powell. And I'm like, well, what does that have to do with the price of tea in China here? If we have something past Leeds Ferry that is absconding with the water, well, that's not really our problem, is it? Or is it our problem? I mean, so if our obligations Leeds Ferry and somehow we're trying to get water down to Powell, and it doesn't make it, so we have a connection there with that water not making it to Powell if it made it past Leeds Ferry or to Leeds Ferry for the compact obligation.
Madam Chair,
Go
I'm
ahead.
not sure, Chris, if you understand the question and can answer it better, please do. I don't.
He has his hand up, so it looks like he might.
I'm just going to be bold and try to take a crack at it. So a couple of different thoughts with regard to that question. One, Lake Powell definitely complicates things, right? Lake Powell was built after the 1922 compact, which placed our obligation at Lee Ferry as part of the federal law that's grown up around the operation of Lake Powell. That whole thing is taken into consideration. And so I think the reason why you hear us quite often talking about Lake Powell elevations and Lake Powell releases, it's 15 miles upstream of Lee Ferry, and what happens at Lake Powell necessarily is going to dictate what happens at Lee Ferry. And so that, going back to a question that Representative Summers asked, why are we showing releases out of Lake Powell? Well, the releases that we were showing are what is possible under the current operating guidelines, just to get an understanding if under the current operating guidelines, if you release the minimum that's currently allowed under law, this is where we might expect to be. That's kind of a worst case scenario sort of a situation. With regard to, I think, part of the question associated with, we don't have any control over what happens to that water after it leaves the state of Wyoming. That certainly is something else that the states have been working on. What happens, and I don't think it's nearly as complicated for the Green River Basin. So if you release water out of Flaming Gorge, so if the state of Wyoming reduces its use or otherwise gets water into Flaming Gorge, we have a high degree of confidence that we can track that water, account for that water as it makes its way down to Lake Powell, of course, then before it gets released to get past Lee Ferry, still understanding that we need to fill data gaps with regard to that system. The more complicated one is on the Little Snake. And how do you get past head gates on the Little Snake or the Yampa in the state of Colorado? And the answer to that question is, if the upper basin is in a curtailment situation, and that is all the upper division states have a joint obligation at Lee Ferry under the 1922 compact, the other states are going to have to work with us in order to ensure that our portion, whatever our obligation is, our portion of the obligation makes its way through their system and shows up at Lake Powell. Just one additional thing that we still need to do additional work on to make sure that happens in a way that everybody can agree with. Hopefully I answered your question.
Representative Conrad.
Thank you, Madam Chair. And following up with that, to the SEO, our portion of the upper basin is 14%. That 14%, to follow on upon Senator Kolb's question, is that 14% value measured, just for my clarification, at Lee's Ferry?
So-
Madam
Go
Chair,
ahead.
it's 14% of the available supply to the upper basin. Or a maximum of 7.5, the 7.5 million acre foot. If that water, if there's more than that available, then 14% of 7.5 of the available supply in the upper basin is what our apportionment could be. If the available supply is less than that, it's 14% of whatever that available supply is. The complexity to that, though, is that water has to be in the right place for us to be able to use our apportionment. So largely, we are under our apportionment most of the time right now anyhow, and that's because of that situation where it's just not where it needs to be for the uses to occur.
And as a follow-up, measured at Lee's Ferry.
Yes, the available supply is actually, I believe it's measured at Lake Powell. Chris can correct me, but it is intended to, the available supply at above Lee Ferry is what our 14% is based on. Go ahead,
Alright.
Chris.
Does that
So,
answer-
Madam Chair,
ahead, Chris.
Representative Conrad, let me see if I can make it just a little bit more complicated than even the state engineer described. Not only is our 14% of the amount of water available in any given year that's available, and that's how it's described in the 1948 compact, we always have to remember that what we were apportioned under the compact isn't water. We were apportioned 14% of beneficial consumptive use that's available in any given year. And so you have to, it becomes a whole lot more complicated once you start looking at what was the consumptive use made of the water, what was the total available for consumptive use in any given year, what goes into that equation with regard to that. Generally, I think you'll see what we look at, and there are differing opinions on this, and I don't want to lead you down the road that this is absolutely the final answer because it's never been done. There's never been a curtailment. So there are a whole lot of things to think about with regard to exactly how to do it. But there is a natural flow estimate that is made by the Bureau of Reclamation every year, and just for the purpose of trying to understand what might be available in any given year. That's typically what we look at. And then you have to take a look at what was the consumptive use made in each of the upper division states in relation to the amount that was available in that particular year. And so it's a very complicated analysis that has never been done, and that the upper division states have never fully developed rules on exactly how it would be done.
Follow up?
No, great. Thank you. That's very clear. Thanks.
All right. Okay, Representative Summers.
Madam Chairman, obviously, we've got, a lot of other compacts in Wyoming. We've had other court decrees. But the Colorado River is the only one where those decrees or compacts are measured in consumptive use and not some other measurement than otherwise we'd have already been through this exercise on the plat or somewhere else. That question's for you,
Chris, did you
Chris.
want to take?
Yeah. Um, Representative Summers, that's absolutely correct. This compact is unique in the way that it divides up water. I think the only thing that we have that's even remotely comparable is that under the 2001 modified decree on the North Platte, we have both an irrigated acreage cap and we have a consumptive use cap. And so at least under the modified decree, the state of Wyoming, under procedures that were agreed to by the states in that decree, has to make estimates with regard to consumptive use. But so long as we stay under those caps, which we have since the decree was put in place, then we are in compliance with that decree. So there is an element of consumptive use on the North Platte, not a straight apples to apples comparison to what we see under the Colorado River compacts. But you're absolutely correct. Under our other 5 compacts that we have, consumptive use is not the measure of the obligation.
All right,
Mm.
go ahead.
Madam Chair, I'd just add one thing, that the consumptive use calculation in the North Platte, it is defined. Here's the process for how you calculate that consumptive use. So that also is a little bit different. That was defined in the decree.
All right, thank you for that. Senator Hicks?
Madam Chairman, just more commentary than question, but it seems to me like with this whole issue of conserved consumptive use and how we're going to model this to find out how much of that's going to make it to Lake Powell seems a little premature in the context that it's all predicated on assumptions and the circumstances on the ground can change year to year. Hydrology, but it seems to me more importantly, and this is the question part of this, is until you have an adequate regulatory framework to be able to measure, evaluate, and track that water, all these models predicated on what that conserved consumptive use and how far that makes it down the river is kind of irrelevant until you can actually provide the certainty that as the conditions on the ground change, it's just an exercise of spending a lot of money and collecting data that really doesn't ever lead us to the point that we need to get to. And that's how do we get water to Lake Powell? Even if we achieve conserved consumptive use in the Upper Green River Basin. This whole discussion about do we get credit for it when it leaves Wyoming or when it leaves Lake Powell is irrelevant because we can't track it. We do not have the adequate regulatory mechanisms in place to be able to track that. Now, we may spend a lot of money in Wyoming, but as soon as it crosses the line, unless the neighbor's doing the exact same thing, same methodology, agrees with how we're doing things, doesn't mean anything. So where are we at with this whole discussion in the UCRC and the Upper Basin states about developing a regulatory framework for being able to, and I know we've had some discussions on this. So when we say that we've conserved X amount of acre feet and we document that the other states agree with that. And if it does show up at the line or as part of a release in Flaming Gorge, they track that as part of our block of water contribution to Lake Powell as the overall system. So where are we at, Brendan, on these discussions?
Before you answer that, I'm going to pile onto that for just a minute because I've been waiting for a turn to add this to the conversation, and that's the conveyance laws. So who's responsible for that and how do you account for that? Because obviously no system is the same, and you know, we may have less loss in Wyoming than they do going across Colorado or the more miles and into Lake Powell. And does it evaporate more in the lake or when it's running down the river? You know what I'm saying? The conditions that we're dealing with as far as conveyance loss. So when you hit that point, it might be a good time to insert the conveyance loss too. And who has to make that up?
So, Madam Chair, I'll start with getting the water to a state line or to Lake Powell. So remember, this is a consumptive use compact. So Kevin, feel free to jump in, but we would use the same methods that we administer water today. But the I think the difference is, and we're using, you know, we're looking at EE metric to help estimate, conserved water on our irrigated lands, and we've got some studies going on to what other outside the irrigated polygon impacts and what kind of savings does that generate. All that's being baked into this. But quite simply, the idea is that you know that this field, if you turn the water off based on EE metric or whatever we're using to determine what the consumptive use is, you're going to save that much. And Kevin and his crew, through their administration, will shepherd that all the way down to Flaming Gorge. So that amount of water based on, and you're, Senator Hicks, you're exactly right, that it's going to, Kevin and his crew are going to be changing this likely daily and daily and daily, depending on the conditions. But it is the amount of the conserved water that gets shepherded down to Lake Powell. So
not to
Kevin-
be argumentative, but show me the statute that gives the Board of the Control the authority to do that.
So
Because these programs are voluntary programs. I'm not aware of anything that gives the Board of Control the authority under an SCPP or the current statutory framework that says that he's going to shepherd it past 26 head gates or diversion structures because it's now system water or they're enrolled in some program. That's the part that the regulatory stuff. And if I'm wrong, somebody correct me, but I'm not aware of any statutory authority that the Board of Control has to do that.
Madam Chair, I was speaking if we were like in a curtailment or something like that. But for an SCPP program, you're absolutely right. We don't have the authority to shepherd that. And that's why we were very careful, as Chris described, making sure that our program wouldn't have that requirement that we would have to shepherd that.
Yeah,
So-
and I agree with you because under curtailment, it's prior appropriation doctrine and you just start shutting them off. That's a
That's
whole
correct.
different deal than all of these other programs that are out there. It's much more clean shut when you just run on prior appropriation doctrine, right up until the point that we have all the exchanges going on and at that point, Kevin will resign. Anyway, but that's the point. Until we resolve this issue of being able, before we get to curtailment, the objective is not to ever get to curtailment. We do not have an adequate regulatory mechanism to be able to facilitate that. Am I wrong?
Currently, that is, I would agree with that we don't have the authority to shepherd conserved water.
Thank you.
Chris, did you have your hand up again, or is it just always up?
No, I stuck it back up, if I might, Madam Chair.
Go ahead. Sure.
So Brandon's absolutely correct. If the question, with regard to curtailment, we do have the regulatory structure in place to do a curtailment. Whether or not we've got the people is a different question. The answer to that question is no. In order to actually get that done, we certainly do not have a sufficient number of hydrographers and commissioners to make that happen. The other thing I wanted to circle back, I think, to your question, Senator Steinmetz, with regard to the transit loss and the evaporation. I think generally, because our portion of the obligation is at Lee Ferry, we would be responsible for the amount of the loss associated with getting that water from its place from Wyoming to Lee Ferry. And so part of why we are supporting the transit loss studies is to have a better understanding of what that would be. And what that ultimately means is if our obligation at Lee Ferry is, for example, 100,000 acre feet, we're going to have to save more. And we need to be able to accurately estimate what that amount is. With regard to the evaporation, the 1948 compact already states that the upper division states share proportionally the evaporation in the initial units. And so for Lake Powell and Flaming Gorge, Wyoming shares proportionally in that evaporation. Lake Powell recently had an evaporation study done, so we're I think those estimates are fairly solid. Another study, because we simply do not have enough right now, that we're supporting moving forward is additional evaporation studies for Flaming Gorge, potentially Fontanelle, so that we have a better understanding or a more accurate estimate of the evaporation that occurs in those reservoirs. For Fontanelle, Wyoming is 100% responsible for the evaporation out of Fontanelle, just like it is for all the other storage in Wyoming. And just for the committee's reference, evaporation is our second largest use, and that's not even including our proportionate share of Lake Powell or Flaming Gorge or Blue Mesa.
All right. Any further questions? Seeing none, go ahead and take us home.
Thank you, Madam Chair. So just the other component to this timeline that I wanted to share. I mentioned that the 7 basin states are still working towards a consensus agreement. So we believe that by the end of 2025, we need to have that ironed out so that it could be implemented in time to establish the operating criteria for water year 2027. So that's kind of the timeline that we're on, that we're still negotiating with the 7 basin states.
Go ahead, Representative Summers.
So, Madam Chairman, thank you. So that it's a pretty, it seems to me like there's a very wide division between, your curves may look somewhat alike, but the practice of implementing each of them is much, much different. And one of them requires authorities you don't have. And so, you know, you can't predict the future, but what's the odds you're going to have to ask for some kind of statutory change? Because that's going to be really probably hard to get. So is the reality, you know, you can't guess where the negotiations are going to go, and you can't tell us how you're negotiating, but I don't see how they give up on their stance that we have to cut so much water, and then some kind of amount of water. And then how do we get to the place where you have the authority to actually cut that water?
Well, I sure don't see Chris's hand up on that one, so I guess you're on your own.
So Madam Chair, Speaker Summers, you're right. I don't think I can agree to something that I don't have the authority to implement. If the negotiations come to that, then I would have to obtain something else. But that's how we're in this, because the other 4 states have similar issues. But I can't agree on something that I don't have the authority to administer. So,
Madam Chairman, just to follow up.
Go ahead. Or did you want to hear from Chris first? He hasn't hand
Well,
up.
Madam Chairman, I think my question will go to Chris.
All right, go ahead.
And this goes to what other states' law is compared to Wyoming's water law. But I assume that you are trying to examine the wiggle room in statutes, just like other states are probably trying to examine how much wiggle room they have within their statutes. And so that's a question I have. Are you doing that? And how close really is our law to our other upper basin states? And do they have more flexibility in their laws? Because what we, you know, then it gets a lot of pressure if we actually have the most solid piece of law, and our other upper basin states maybe can get away with more as it relates to uses and priorities and all that stuff. So how do we compare with other states, and are we at risk of being the lone man out, which I don't mind at all, by the way?
Chris, it looks like that one's for you.
Sure, Madam Chair and Mr. Speaker, we have done quite a bit of work comparing the different authorities in the states associated with, and if I'm understanding you correctly, we're primarily talking about shepherding. And so each state has taken a look at that question and what potential authorities may be needed in order to get that happen. And it really depends on how this evolves. And one thing that that I wanted to add to what Brandon said. I mean, you're absolutely right. If we are not in a situation that is a curtailment under the 1948 compact, because if we are under a curtailment, then the authority flows directly from the 1948 compact, which is a Wyoming statute itself. So that's where that authority comes from if we're under a curtailment or if we're engaged in whatever activities to comply with the 1948 and the 1922 compact. But if we're simply talking about voluntary, compensated, conservation type programs, that's where, as the state engineer mentioned, the authority doesn't really exist. And so with regard to shepherding, that water is saved. How do you get it past another Wyoming head gate that is lawfully entitled to divert that water? And the states are different. Not surprisingly. I mean, we all follow the doctrine of appropriation, where we have quite a few consistencies with regard to how the law works, but quite a few inconsistencies as well. I will mention that the state of Utah has already passed a statute which granted the Utah state engineer the authority to shepherd conserved water, demand management water specifically identified in Utah. The New Mexico situation is quite a bit different than ours, simply because there's a whole lot less space to get the water through in New Mexico. I would suggest Colorado's perhaps well, not even perhaps, they're in a more complicated situation than we are, because the Colorado River gets delivered to all four corners of the state of Colorado through some very complex systems. And so probably in each state, some additional authority would be needed to shepherd any sort of voluntarily conserved water, like Utah already has, arguably. I think there's some additional things the Utah state engineer would like to see, but that will leave it up to Utah to figure that out. But I would just point out that I don't know, and this is part of the negotiating space with the lower basin. Are they going to require that we shepherd the water? Is any conservation program that we can ultimately potentially agree to going to have that particular element? I think these are all still things that are part of the discussions. If we're able to set up a program that the lower basin is satisfied with, do we need to have those particular authorities? And so, and I know this can be exceptionally frustrating, because we'd like to pull the trigger on some authorities to try to fill any gaps that we might perceive, but until we know precisely what our future looks like going forward, we would have a pretty good risk at pulling that trigger and missing the target, because we don't know exactly what that looks like into the future.
All right, well, we're gonna let that horse try to rest in peace. So we'll go on with our presentation. Thank you.
And Madam Chair, I'll try to be very brief. We can go ahead and go to the next slide, please. But this is just some of the funding. Again, you guys will all have this, but if you have questions, want me to dive deeper, please do. But this is some of the money that Wyoming legislature has appropriated to the SCO. We're working on developing a riverware model, building a website for the Green River. It's similar to what's being done on the Bear River Basin. It's kind of a real-time stream flows, a host of things that you can see on one screen. We're doing some of the studies that Chris and I talked about earlier, transit loss, water availability, and then I think most are probably familiar with water development's study for conveyance loss. We'll go ahead and go to the next one. Some of the federal funding, the $50 million from BIL to support upper basin drought contingency plans. Please go to the next one, talk a little bit more specifics. So this is the bill funding. Last year, the UCRC received 8.7 of the $50 million. Some of the studies that, or some of the things that money was spent on were EC towers. Wyoming received 4 EC towers. Wyoming received 10 stream gauges. And then field water balance studies. And these are occurring all over the upper basin. The numbers I'm providing are what Wyoming got from that. Then the 24-25, we're developing the spend plan for how that money will go, but I think the general consensus on where that money will go is this list of items right here. How much goes to that is what we're still determining. And I'll point out that the next tranche of money for 24 and 25 is just about $30 million. And so the year 2 spend plan, I think one of Wyoming's priorities is diversion measurements, diversion from the main channels. So that'll be part of this spend plan, as well as some additional stream gauges, reservoir evaporation studies, the incidental use studies I mentioned earlier. If you look at the irrigation polygon, you take the water off of that, other things dry up too. And what amount of conserved water is associated with things outside the irrigated land itself. And so we're trying to get better understanding of that with some of this money. And then just improvements to our data, our remote sensing data using the EC towers, trying to get hone in on better data through that. So that's some of what some of this money will be used for next year. Next slide, please. So Inflation Reduction Act, the IRA funding, there's been a lot of discussion on that. So bucket 1 was the System Conservation Pilot Program, voluntary compensated temporary program that was in 23 and 24. Wyoming participated in that. Point that I wanted to make on this is that the UCRC is seeking reauthorization for this SCPP program. There's been no decision on whether there will be another SCPP program, but we felt it was a good idea to at least have the option that if we need to continue with some sort of conservation program in light of when the timing of bucket 2, and we'll get to that when that would come out, just as a backstop, we thought reauthorization of SCPP may be valuable, and then we can decide whether we can use it or not. Next slide, please. Just some totals of our 2023 SCPP project. Then the next slide is the 24 summaries. And if I'm going too fast, please have me explain more. Okay. Next slide, please.
Suspect why there's more participation in Wyoming than the other states.
All right, I'm gonna either ask you to turn on your microphone, or I can repeat that for you, or if you would for the people out there. And
So if you look at
TV land.
2023 and 2024, Wyoming has had a little higher participation than any of the other basin states. And yet, again, we are only 14% of the allocation in the upper. Do you have a hypothesis as to why?
Perhaps a couple of things. I really don't, Senator. I know some of the states just philosophically had issues with this. I think from my perspective, I thought it was something that each individual can choose to do in our state if they so choose. That's kind of how we presented it, that if you want to participate, here's how you participate. But I don't really know the ins and outs of the other states. So I'd hate to hypothesize too much. Go ahead and go to the next. So bucket 2 funding, remember the IRA funding was $4 billion for the 7 basin states. Of that, 500 was dedicated to the upper basin states. And so whatever is left over from SCPP So the money spent for SCPP was part of this 500 million. I think that 400 million is probably more closer to 450 now, we're seeing with what we spent on SCPP. But these would be for the longer term compensation for temporary and multi-year reductions in consumptive or reduction in diversion of water or consumptive water use. Voluntary system conservation projects that achieve verifiable reductions in use of demand for water supplies or provide environmental benefits in the lower basin or upper Colorado or upper basin of the Colorado River. And then ecosystem and habitat restoration projects to address issues directly caused by drought in a river basin or inland water body. That's the direct language taken from the authoring legislation. So bucket 2 now has been divided up into environmental projects and longer term water conservation projects. And then the bucket 2E is the ecosystem and habitat restoration projects. We'll get to that here in just a second. We go to the next slide, please. So we know that these have been discussed for a considerable amount of time. In July of 2022, Reclamation announced the release of the 2E, the environmental projects. Some important things to note with that is that that funding will go directly from Reclamation to a public entity. It will not go to private individuals. It's got to go to a public entity of some sort for these environmental types of projects. So you would have the interested applicant would have to work with the public entity of some sort, whether it be a conservation district or.
We have a question. Representative Summers.
Madam Chairman, that was what I was going to ask. Public entity is not an NGO, right? So it would have to be the state, a conservation district, or NRCS maybe, or something like that. I don't know.
Yeah, Madam Chair, I think it's a subdivision of a governmental entity. So applications are currently open for this. Reclamation will accept the proposals until October 14th of 2024. And if anybody has additional questions on this, please feel free to reach out to my office. Jeff Cowley in my office can help them out. But just pointing out that we started coordinating some with water development, the game and fish, the WWNRT in our state, and some of the conservation districts to inform them and get the word out that this money is out there. Next slide, please. So bucket 2W, the long-term water conservation funding. The states are still working with Reclamation on developing an MOU. We're fairly confident that funding will go from Reclamation directly to a state entity. So in Wyoming, you all in legislature have already authorized water development to take this funding. So that we can do that, we can run it through them. And from water development, then it can go to a private entity. And I think everybody's aware of that connection now, but we hope to have the agreement with the UCRC yet this summer. Shortly after that, then the states would have to enter into an agreement with Reclamation to accept that funding. And then all the criteria and eligibility would be associated with those agreements as they're developed.
Go ahead.
Madam Chairman, thank you. And I know I've heard this, like 4 times in the last month, but why in the world aren't we understanding what they're going to allow and what they're not going to allow? I mean, why don't they get this thing at least where the public or the people involved understand what it's going to be used for? What's the holdup?
Madam Chair, I may phone a friend on Chris. He's been much more involved in those discussions if he's still on.
Chris, are you still there?
And Madam Chairman, is the holdup the federal government, or is the holdup the upper basin states, or all the states?
All right, go ahead, Chris, if you want to take that one.
Madam Chair, Mr. Speaker, the answer to your question is yes. The holdup is the federal government and the states. There are a few different, I'm not even sure what I want to call them, considerations, I guess we'll call them at play. We have made quite a bit of progress on a draft agreement between Reclamation and the states, and a lot of the concern, and I think it's fair to say that Wyoming even shares this concern, is trying to be very careful such that the Secretary of the Interior just doesn't come into the state of Wyoming and start providing money to folks to engage in these kinds of projects. We're concerned about relinquishing any state control or authority over water. And so that's part of the back and forth. I'm sure you'll probably guess that the Department of the Interior, who was provided this money from Congress, believes they have the authority to come in and enter into an agreement into agreements with public entities within each of the states. And so we're trying to be very careful to make sure that this is done in a way that doesn't harm Wyoming water users. And so because of that, and we're going to have an agreement that has all the states, we have to figure out how to stay consistent, not only between the upper division states, so we don't have some state approving projects that the other states believe is contrary to the purpose of the program, which is essentially to provide for long-term water conservation type projects. So we have to get together and have a common understanding, a consistent understanding of what that looks like. That has to match up with what the Bureau of Reclamation is considering at the same time. And to throw an extra challenge or perhaps opportunity into the mix, there's special mention in the IRA for tribes. And so we've been discussing how potentially the 6 Upper Colorado River Basin tribes would work into this process. And it's been complicated trying to work through all those questions. And so the answer is it's a little bit of everybody trying to make sure that this is done in such a way that doesn't ultimately result in some sort of harm to an individual state. And we're staying together. We're staying consistent. We're staying in a way that we're not contrary to one another at the end of this thing. We do have a fairly good draft, I think, right now that we're working on. The next step will be working out an agreement with each of the states, which is just more of a process. How's it going to work in that particular state? Obviously, Wyoming has the very capable Water Development Commission to deal with. The other states don't have the Wyoming Water Development Commission. And so they need to work on agreements on how just procedurally it's going to work within those states. And then ultimately there'll be a grant that will be provided to each of the states once the process for approval of projects makes its way through. So probably not a satisfactory answer like most of my answers, but there are a lot of issues that we're trying to work through or avoid with the upfront agreements. And I guess I'll mention again, the tribes. We just met for the last 2 days with the Upper Basin tribes. One of the reasons why my calendar didn't let me be in Evanston, trying to make sure we understand what their perspective is, what their concerns and interests are, what they're thinking about with regard to some of this IRA funding. And so just trying to bring all those things together in a way where they work together.
We are going to have a follow-up, but before we do, I just want to highlight and thank you guys for watching those federal requirements for our water users and for our state. We know that you are guarding them for us and we really appreciate that. So follow up, Representative Summers.
Madam Chairman, thank you. You know, and I know this is not, my request is not going to be a shock to you, but I would really like to see, since you've begun to form a draft product, and I think at least an executive session, that the Colorado River Advisory Group, the Wyoming's Colorado River Advisory Group, ought ought to be able to provide input into you folks about where we think you should head or not head in that document. I mean, we did right at the beginning, kind of in the fact that we created a laundry list that looked like NRCS's list, I think, and we did some stuff like that. But now that you're getting down to brass tacks, what I don't want to see happen is we get the thing and 2 hours later we get to comment on it. We have 2 hours to give you a comment. That one is getting really old and tired.
So
All right, and I think wouldn't you agree? On that one, but if you have a comment, go ahead, Chris.
no, Madam Chair, and I definitely appreciate and certainly not the first time I've heard that concern from Representative Summers or other members of the advisory committee. And right now, the status of that document, we finally got all the states on the same page of what it was intended to do, kind of had it boiled down to a pretty thin framework and started to start building that out, waiting for some response from the solicitor's office, the Bureau of Reclamation, and Brandon and I haven't talked about this at any great sort of depth, but my expectation would be that after we get some of that additional meat on there, we'd be doing precisely what the speaker is requesting.
All right, thank you very much on that. And it looks like we're almost, you've almost got us there. Take us home.
Madam Chair, we're home.
Ma-
All right,
I'm done.
We're
Madam
home.
Chair, could,
yes,
and
go ahead.
Brandon, I apologize. I should have mentioned this to you. Along the lines of, we certainly want to make sure everybody's aware of what's going on. There will be a UCRC meeting on Monday, in part to talk about the Bucket 2 funding, where it's at in the process. And I think perhaps related back to Senator Hicks's question as far as getting credit. Just another thing that we have been working on is trying to, and I think you heard at the UCRC meeting in Cheyenne, the states in reclamation working on concepts to potentially get credit for this conserved water, how to track it. And I think we're going to have a proposal to try to move that forward, which is really just a kind of a proof of concept idea moving forward that's going to require a whole new agreement. But just wanted to make folks aware that that likely is going to be a discussion by the Upper Colorado River Commission on Monday, that process is moving forward as well, as far as how to get credit for some of this water that we're talking about.
All right, thank you for that. And remind us, as for those watching online, is that a streamed meeting, and can they find it at the state engineer's website when those meetings occur?
Madam Chair, they should be posted on our website, but they would also be on the Upper Colorado River Commission webpage as well.
All right, so for those listening online, that's where they can find that. Thank you for the comprehensive presentation, and we're always interested in this subject, so thank you for bearing with us as we ask all our questions. Does anyone else have any further questions? Seeing none, then we will go to public comment. Is there anyone in the room or online that has public comment on the Colorado River Basin update? Any questions from legislators online? All right, seeing none, we will close this section of our agenda and go on to the disposition of water rights discussion. You guys will be up again, as I think we had left you the task of seeing how the law we passed in, I can't remember what year that was, 2022, House Bill 2, which was how we had talked about how we deal with water rights with regards to subdivisions. And then we had some concern from the Wyoming Association of Municipalities and Senator Kinski that was presented at our last meeting. He had a repealer that he had run last session that didn't make it through. And so we decided maybe to approach this in a different way by going to your office and finding out how this change in law was being administered with regard to expense, and if there's any way we can streamline it and make sure we're not also abandoning water rights that then would affect, other, how much water is running downstream to other states and things like that. So do you have an update for us on that?
Madam Chair, I do have an update. Actually, David Schroeder, Superintendent of Water Division 2, has an update on that. Dave, if you wouldn't mind providing your update.
Welcome, Mr. Schroeder. Can you hear us? David Schroeder, are you with us?
Thank you, Madam Chair, members of the committee. Thank you for having me today. I was going to give a quick refresher on why we're here today, but the chairman did a terrific job of doing that, so I'll get right to the heart of the matter. And if you recall, in the May Select Water Committee meeting, we thought we could address some of these concerns with development of water rights and House Bill 2 through agency rule and amending some of those. Specifically, we landed on the topic of contested case hearing notices. You may recall the water rights petition that Senator Kinski referenced at the May meeting that involved approximately 1,000 residents within the city limits of Sheridan that needed to consent to the petition. This was to define acreage on that petitioner's property. Because the petitioner could not get 1,000 people to consent to his petition, the docket was referred to a public hearing to satisfy said consent. I do want to point out that this petitioner is defining this territorial blanket water right in order to distribute it on his intended development. There were other less burdensome options available to him, but keeping an 1881 water right was important to them. The problem stems from the hearing notice requirement found in Board of Control Rules and Regs, Chapter 6, Section 3B, which requires, and I quote, "Any person whom the board knows to have an interest in the matter shall be given notice of the proceedings and all motions or pleadings by certified mail, return receipt requested," end quote. Also included in this procedure is a legal advertisement in a newspaper of local circulation for parties unknown. As we discussed earlier, this can get quite expensive when there are many parties that need to be noticed. The Board of Control Administrator submitted emergency rules to the Secretary of State on June 26th, and they were certified on July 8th. This authorization allowed me, as the designated hearing officer for this petition, to allow the petitioner to send out hearing notices to affected parties by regular mail, and also place 2 notices in the legal section of the local newspaper, which is the procedure allowed in the amended change appointed diversion statute. This action alone saved this petitioner many thousands of dollars. Also included in our emergency rules, and stepping away from disposition of water rights slightly, but also of interest to this committee, we addressed the one fill rule. As discussed last year by this committee, I understand there was some concern that the state engineer's office and our field staff don't allow more than one fill of a reservoir, no matter the conditions. Past testimony from Mr. Gebhardt and Mr. Payne indicated that under the right conditions we can, and our hydrographer commissioner manual does contain language that allows this. However, the Board of Control rule found in Chapter 1, Section 7 did not align with that wording in the manual, and it was suggested to update our rule to match the manual. This change was included in the emergency rule change request and will be made permanent as well. And just to reference that wording, it is possible and allowable for a reservoir to accrue more than its one fill in 1 year if water is available and not needed by any other appropriator. Lastly, just a minor housekeeping update regarding water rights petitions and a cutoff deadline. To to allow board staff enough time to review a petition project and prepare a presentation for the upcoming meeting, the board issued a policy memorandum a few years ago to extend the deadline from 30 to 45 days. We found 30 days to be insufficient in many cases. The agency rule is now being updated to match the policy that has been in effect for some time. These emergency rules expire after 120 days, so generally in November, and we are working on the permanent change. These permanent changes must be promulgated before they expire to make them permanent. I certainly appreciate the opportunity to provide this update and would stand for any questions.
Thank you, Mr. Schroeder. That is good to hear that you remedied the situation that we heard about last meeting. So is there a procedure then available to another entity that might come up against this? Will they be forced to do an emergency rule change as well for you? Or what is the procedure going forward for someone else who hasn't come to their senator, who came to our meeting and presented their problem? What is the ease of doing business for our citizens out there with regard to an issue like this?
Madam Chair, if I understand your question, and first I apologize, I hadn't started my video.
That's all right. We thought maybe you didn't have enough signal. We've had a little bit of that today, but we're glad to see you, and go right ahead.
Sure. So the intent of the update, if you will, to the change in point of diversion statute was to allow this modified hearing notice procedure when there were more than 20 individuals needing to be notified. So, and it gives the board the authority or the option to give them this modified procedure. The regular rule will still stand. If there's only 5 people, then we're going to have them send out certified letters. But the petition in Sheridan is truly the worst case scenario. But we do see petitions in front of the board that involve dozens and maybe even hundreds of folks. Mr. Payne has one in Afton in particular that may benefit from this. And so the Chapter 6, Section 3B rule will still exist for most petitions, but giving some break when the notice requirement could be deemed burdensome.
All right, that clears that up for me. Any questions, committee, for Mr. Schroeder? Any further comment from the state engineer?
Only to thank you for the work you guys do, and thank you for allowing us to be here today.
Well, we appreciate it, and stick around because we might have some public comment that we might need you to. So, Representative Conrad, you almost lost your opportunity. Jump in there.
Madam Chair, thank you. I just want to thank you guys for, more importantly, coming across and coming through the country here, visiting with the local areas, because it was extremely powerful, educational, and our local guys and gals truly appreciated it. Thank you.
Great. It's good to hear good news after our Colorado River update. So, with that, for now, we'll go back to public comment, and it looks like we might have had a couple of people online. I'm assuming that because we're at the end of our agenda, that possibly they wanted to speak on this issue. So is there someone online who wishes to testify? It looks like we may have Brett Moline and Carrie Agan, if I'm saying that right.
Carrie Agan did have her hand raised.
Oh,
for
Carrie
testimony.
had your hand raised. Go ahead, Carrie. Why don't you start first? Welcome to the Select Water Committee. And we're listening for your testimony.
Can you hear me?
Yes, we can.
Okay, great. Thank you very much, Chairwoman. You're right. My testimony does incorporate most of this day, but especially the topics after lunch. Sorry. So please note that my comments are not intended to denigrate the efforts of all those on this committee and all others working on water issues. You guys have been working really hard. but I'm hoping that these might help in some way. First, a lot of Wyomingites are extremely concerned that certain high-volume industrial water users will have priority over water use, groundwater and or surface, over household uses and other industrial water users who use less water. Of particular concern are the data centers that are planned and the various crypto mining facilities. If I understand correctly, all of these facilities use huge amounts of water to cool the computing equipment. However, these uses offer virtually no return to the people of Wyoming except to add to the state coffers. They add virtually no long-term jobs for Wyomingites, only specialists which will likely come from out of state and possibly even other countries. If these high-volume users also take priority for water use, the state is unequivocally saying to Wyomingites and lower volume water users, including wildlife and ag uses, that the most important priority to the state is money funneled into the state coffers. Second, if groundwater truly takes priority over all other uses, this essentially encourages the drawdown of groundwater, potentially to levels as devastating to other uses, including those supporting human and animal life. Third, there is no reasonable reason whatsoever why California, and indeed Oregon and Washington state, cannot provide a lot of water to themselves and possibly other states also via desalinization of seawater. This is a viable and cost-effective methodology and is routinely being used on a large scale in a number of Middle Eastern countries. If California, Oregon, Washington state are encouraged to pursue this, perhaps even incentivized, such endeavors would free up vast quantities of surface waters from restrictions within those states and in surrounding states like ours. The terms drought, water restrictions, and even curtailment could be made virtually obsolete almost overnight. This would forever change the dynamics of Wyoming and every other Western state. The fact that no one, including the states within the multi-state compact mentioned and other agreements, and the governors of these states, including ours, is pushing or incentivizing for desalinization makes it extremely apparent that ensuring sufficient water for all uses, but especially ag, is not the priority. Politics are. This is very bad for all concerned. Thank you very much, and I stand for any questions.
Thank you. Thank you for taking the time to be with us today. If you would, there's a lot to unpack there in your testimony and some things that I think we could probably help you straighten out as far as water for man and beast is a preferred use. It is in our state statutes, and so there are some rights associated with that. So water for man and beast has always been important in our state. And then we're a prior appropriation doctrine state. So it's first in right, first in time. So if you look up prior appropriation doctrine, you will find more information on that. And I can send you more information if you go ahead and email me directly on my legislative email. So, and then I think it will allay some of your concerns.
Thank you, Chairwoman. I will definitely do that. Thank you.
Yes, you're very welcome. Thank you for taking your time to be with us today. All right, and I see that Mr. Moline has indicated through the chat that he does not wish to testify on anything. And so with that, we have one more. I'm going to close public comment, seeing no one in the room or no one else online that is wishing to comment. We will close public comment. I do have one more thing just to add to the end of our agenda, and that is Donna has prepared a wonderful document for us, and I don't know if she's had the time to pass those out yet, but it is a resource for everyone here. At one of our last meetings, we weren't able to award funding to a number of projects, and as funding gets shorter across the state, this will be a resource for our constituents and for legislators as they serve them. And so Donna, if you could just tell us a little bit about the resources you put together, and I'll go ahead and let the state engineer go, thank you guys for being with us. Thank you, Chris, for taking time online, and for our Board of Control members that were here. Thank you very much. We appreciate all the information and all that you do for our state. Appreciate you guys. You said I was in charge. All right, go ahead, Donna.
Sure. Chairman Steinmetz at the last meeting asked LSO to put together a list of other water development funding sources. And with great help from the Water Development Office, both Barry and Sarah, I did this, and you'll see that there are quite a few other state sources and then multiple federal agency sources of grants and loans and loan guarantee programs. And then a couple of non-governmental organizations are listed too. So hopefully this will be helpful to everyone. And I don't know, Chairman Steinmetz, whether it would be helpful to have Sarah, the grant administrator with the Water Development Office, provide some more information about, to the committee.
I think we're good. I think this will just be a valuable resource. And for those listening online, we will be posting this, or for legislators that are listening online, we will be putting this in our meeting materials after today. So if you need to go back and find this digitally, you'll be able to download it there and have that available if you missed the email. So that's our last item. And thank you for all of your hard work on that, and to Water Development. Again, thank you to the team at the Water Development Office for a great meeting and tour. We really enjoyed it, and a great lunch. And we will see you at the next meeting. So with that, committee, is there any further business that anyone would like to discuss, or any items, housekeeping from staff, anything? All right, seeing none, enjoy your summer, have a safe drive home, and we'll see you down the road. We are adjourned.